Hello, dear friends. This is Uyana Consulting and Legal Practice. My name is Carlos Salazar. Today we are going to check on the basic theory of law. We are analyzing Chilean law, the Chilean legal system, and as a manner of introducing ourselves into the vast universe of the Chilean legal system, what a better place to start than the general theory of law. So to the purpose of this video, I have prepared a set of slides in order to explain some key points of the general theory of law under the Chilean legal system. So here we see that there's a Chilean flag and a Lady Justice with the scales. It's a really nice picture. And let us begin with the general concepts we are going to review today. We have private law versus public law, the concept of law, what is legal custom or custom, jurisprudence, the general principles of law, and equity. So those are the concepts we are going to review in this video. So let us begin with the private law versus public law distinction. Private law could be defined as the set of rules referring to a person, to the organization of families, and patrimonial activities. Let us remember that patrimony is the concept of the net worth of a person's assets and liabilities. This definition of private law is taken from a manual called Derecho Civil en Preguntas y Respuestas by Aníbal Cornejo Manríquez. So the book is right here. Aníbal Cornejo Manríquez, and he has written this manual of civil law. So I took the definition from his book, and I also used many definitions from this work by him in order to prepare these slides. So another definition, an alternate definition, would be a set of legal rules regulating the relations of private individuals with each other and with the state when the latter acts as a private individual and not as an authority. So this definition comes from Jaime de Solmiñac Iturra, and I also took it from Cornejo's book. So when we talk about public law is also defined as the set of rules regulating the organizations and activities of the state, as well as rights and other minor political entities, disciplining the relations between the citizens and other political organizations. So when we speak about minor political entities, we are talking about the municipal councils, the local city councils, which are not considered part of the state directly, but they are also under public law. And what are the activities of the state? According to Cornejo, we can divide the activities of the state in the constitutional function, the administrative function, the judiciary function, and the legislative function. The constitutional function is the one that has to do with matters related to the Constitution. The administrative function, it has to do with how does the state put into practice the different norms, the different rules, either from the Constitution or from laws. And the judiciary function has to do with the activities of the tribunals, the courts, whereas the legislative function has to do with the lawmaking process in the Congress, in the Senate, and the Chamber of Deputies. So that is public law. let's explore the concept of law itself. No, so first we have the Article 1 from the Chilean Civil Code says that la ley es una declaración de la voluntad soberana manifestada en la forma prescrita por la Constitución. Perdón, la ley es una declaración de la voluntad soberana que manifestada en la forma prescrita por la Constitución manda, prohíbe o permite, which roughly translated would be something like the law is a declaration of the sovereign will which manifested in the manner or the form prescribed by the Constitution commands, prohibits, or permits. And this is the concept from the Chilean Civil Code, and this was redacted by Mr. Andrés Bello. Andrés Bello was a Venezuelan academic. He was actually one of the most brilliant minds in the 19th century Latin America. And yeah, he was also in charge of organizing the University of Chile. Another concept taken from Cornejo's book is a concept by St. Thomas Aquinas, which says that the law is the arrangement of reason for the common good promulgated by the one who is entrusted with the care of the community. So here Thomas Aquinas has a more communitarian concept of law, which puts its focus on first the common good and the community. And we see it's a very Catholic concept of law, but in some way it does reflect in the Chilean legal system, because in our constitution we also have the concept of a common good, of a general well-being, or a common good. So it's also part of the Chilean legal system to have this Catholicizing view of the law. Another more positivist or more technical concept of law is the one given by Marcel Planiol. Marcel Planiol says that a law is the mandatory social rule established permanently by public authority and enforced by force. So from this concept of law, we can extract different elements of what constitutes law. These elements are also listed by Cornejo in his book. He says that for a law to exist, it must be established by a public authority. In this case, it's the Congress. The mandatory nature of the law is also evident. We see it's mandatory for all citizens and inhabitants, which also just another way to say that it's binding to all the inhabitants of a certain territory where the law has its effects. And that's the binding nature of the law. It has a permanent character, which means that the law will have its effects from the time it's promulgated and published here in Chile. We have the what's called the Diario Oficial, which is the official gazette of the Congress. And once it's published in this official gazette, it has its effect in a permanent way. Of course, laws can be repealed, and their effect will exist until they get repealed. So that's another characteristic. We see that a law must be enforceable by public authorities, which means that authorities do have the power to enforce the law in cases where citizens or any person are not obeying the law, or not complying with the law. Then the public authority does have the power, the authority to enforce the laws. And finally, I must also mention that there are other legally binding norms that are hierarchically inferior to the law, such as decrees, regulations, ordinances, and circulars. We are not going to check them out in detail in this video. We will do another video explaining each one of these, but I'm just mentioning them so that we keep in mind that under the law there are also other kinds of legally binding norms. Um, so, custom. We have in our system what we call costume or legal costume. The costume is defined as the constant observance of a specific conduct by the generality of the members in a determined social group, enacted in a continuous and uniform manner with the conviction of attending a legal imperative. So, from this definition, we can also extract different elements. For example, we see that the costume is a conduct. It's a way of behaving. It's the observance of this conduct in a constant and general and continuous manner. So, and the other element we can extract from this definition is that the costume must be observed in the conviction that it is attending a legal imperative. What is a legal imperative? It's also called a legal necessity. So we see that there is a need to comply with a certain imperative, with a certain necessity, where the law does not operate. And in this case, we have a custom, which is the observance of this conduct in attention to the imperative. So we have this the we have two elements. With one would be the subjective element, which is the conviction of attending a legal imperative, and we have the objective element, which is the conduct, the observance of the conduct. Um, the Chilean Civil Code, in its article number 2, it says that la costumbre no constituye derecho sino en los casos en que la ley se remite a ella. This could be better translated as the costume is not a constituting law. It's not law, except for the cases in which law does remit to it. So there are certain cases where law says, well, in order to solve a certain imperative, a certain legal need, we will bind to whatever the costume is. And one example of this is in the case of rentals, in house rentals, apartment rentals. When we have a rental contract, um, it is the costume that the rent would be paid monthly, each month. So if the contract, if the document does not specify, does not give any detail on what would be the payment format, then it is assumed by costume that the payment of the rent would be monthly. That's one example when the Chilean law recognizes costume. So that's all I have to say about this definition. Let's talk about jurisprudence. Jurisprudence could also be defined, and this is also taken from Cornejo's book. It says that it's a general solution given by the courts of justice to matters of law. However, this definition, it's a very broad definition. An alternate definition, also stated by Cornejo, gives more details, and he says that certain matters decided by the courts in a consistent and repeated manner over time, especially if those rulings come from the highest court of the Republic, the Supreme Court, result in what is commonly referred to as uniform jurisprudence. In this way, although the lower courts are not obliged to follow a particular interpretation of the law made by the Supreme Court, generally they do adhere to its criteria, which is a criteria of subordination. So we see that the Supreme Court issues annulments, or casación, as we call it here, and these annulments rulings do result in a uniform jurisprudence. However, the lower courts are not obliged to, in any way, to follow the interpretation of the higher courts, but they do generally adhere to these decisions, and generally they do that because they don't want their decisions to be annulled in the future, to be appealed or annulled. So they generally try to keep it uniform. So although jurisprudence in the Chilean legal system, since we don't have what you call the common law system, where jurisprudence has a binding force, has this binding authority um, with the president and all that, we, in our civil law system, the Chilean legal system, we do have uh, a somewhat binding force, soft binding force, I would say. It's a soft binding force of the jurisprudence, by which generally lower courts do adhere in a voluntary way to the criteria of higher courts. So that's the importance of the jurisprudence in Chile. So what about the general principles of law? The general principles of law are, as also from, they are also taken from Cornejo's book, and let's list them in Spanish. They are called autonomía de la voluntad, buena fe, reparación del enriquecimiento sin causa, y responsabilidad. Translated to English, autonomía de la voluntad would be the freedom of contract, some sort of contractual freedom, or if we translate that more in a more literal sense, it would be autonomy of the will. Good faith, we have the unjust enrichment and liability. So what about freedom of contract? The freedom of contract is a very important principle in our legal system. We generally do have freedom of contract either in form and in content. So people are generally free to choose whoever they want to contract with, and they are free to choose the format of the contract, and they are also free to choose the content of the contract. Now, this principle does have its exceptions, because we also have labor laws. For example, in an employment contract, labor law does modify the content of the contracts, does intervene in the content of the contract. So in that case, the freedom of contract is in some way compromised, or it's relativized by this intervention of the labor laws. That's one exception. But generally, the Chilean legal system is inspired by a very liberal sense of freedom, and freedom of contract is throughout the whole civil code, for example. The principles of private law are very influenced by this principle. So we see good faith. Good faith, it refers to act in a non-malevolent way, and it's also classified as good faith in contract, and good faith in the performance of the contract. And there's also a pre-contractual good faith, which is a good faith in negotiation. There's also the unjust enrichment, which means that the law abhors the fact that a person may be enriched without any legitimate cause. And thus, anyone who falls into this situation would be obliged to restitute whatever they gained in order to return to an original position where such enrichment was not was not produced. So, and finally, we have the responsibility or liability. Generally, when we talk about civil liability, we talk about contractual liability, which means that anyone is responsible to comply with the contract, and in case of non-compliance, there are also consequences um, from this non-compliance. But also we talk about liability in the non-contractual relations from person to person, which generally relates to torts and damages. So those are the principles of general principles of law. Finally, we talk about equity. Equity could be defined as the fairness and justice applied to each concrete case. In this sense, we also speak about natural equity because it's the concept that's from the Chilean Civil Code, and Cornejo has defined this natural equity as a secure and spontaneous sense of what a just and unjust of what is just and unjust, and that arises solely from human nature, independent from positive law. So natural equity is more kind of subjective sense, subjective intuition, which informs us of what is just and what is unjust, and it's independent from positive law. So in this case, natural equity gives some space for the judge in order to evaluate from his own criteria, from its own subjectivity, what is just, what is fair, and what is not. And in this case, this subjectivity gives place to the judge to rule in case in which no law may be applicable. He still may rule under the principle of equity, which is related to what it's commonly called or popularly called the common sense. Okay, so it is a very subjective concept. It's not um, it's not usually applied. It's more in the case of silence, when law has these loopholes, a judge may rule under the natural equity. And here in the Article 24 of the Chilean Civil Code, we see natural equity included as one of the final criteria of interpreting the law. There are in the Civil Code we have different interpretation rules on how to interpret the law, and we're going to review them in another video. This video we are just mentioning Article 24, but Article 24 is the final. I mean, it's the ultimate solution in case that no other interpretation law would be available, or would not we wouldn't be able to use any of the other rules. Then we apply the natural equity in order to interpret the what is how should the law be applied. So that's it. That's for equity. And finally, the book I use in order to collect the information for this video is Derecho Civil en Preguntas y Respuestas, Volume 1. This is a small mistake, sorry. His name is not Álvaro, it's Aníbal Cornejo Manríquez, and the publishing house is Editorial El Jurista, from Santiago, Chile. So that's the reference for the information I use for this video. Finally, if you have any doubts, if you want to ask me anything, don't hesitate. My email is carlos.ignacio number 3 at gmail.com. I am a practicing attorney, so not only if you have any inquiries regarding this video, but if you actually want to hire me as as your legal representative, if you want me to hire you to, if you want to hire me to represent you before a court of law here in Chile, you also may contact me to that effect. I would be glad to help you with whatever needs you have, and please just feel free to write to me. That's it. Thank you very much. Thank you for your patience, for your attention. I hope everything was made clear, and I must confess that I feel really glad to start this series about Chilean law, and to translate these contents for you into English. I hope that we will have a lot of fun in further videos, and I wish you the best. Thank you.